Okay, so let's get into this real quick. There's something you need to know. The SSA, they will super investigate you online. They will look things up about you. They will check into stuff. They will see what you're doing. They will see what you've posted. They will see timelines. They will grab metadata. Some of you don't know what that is. Metadata is data about data. But another more simple way to put it is that essentially it is information that is usually hidden inside a file, or it's somewhere that's not on the surface of what you see. It is metadata. It is data that investigators pull in order to, search and learn things about you. Now, there was this claim. United States District Court for the District Court of Columbia. It was Leah Glass, the plaintiff, versus Andrew M. Saul. And they switched from Nancy to basically Andrew as the commissioner because they swapped him out. The case was essentially number 19 CV 1804 RCL. Okay, 19 CV 1804 RCL. Now, let me give you some of the basic details. We're going to be going through in this actual brief essentially how the SSA will, look things up on you, figure things out about what you've been doing, etc. Now, this is a particularly juicy claim. There are many spicy details about it. That's why I picked it. I think you will enjoy it. I think you will be very like, what the F about it? And that's fine. You know what I mean? Sometimes you got to read a claim like that. Let's get into it. Memorandum opinion. Plaintiff Leah Glass brings in action pro se, challenging, that means by herself, challenging a Social Security Administration determination that she is ineligible for supplemental security income because she is not disabled under the Social Security Act. So she's saying she is disabled. The SSA is saying she's not. Before the court are plaintiff's motion to stay, ECF number 88, and defendant Andrew M. Saul's motion for judgment of affirmance, ECF number 86. After considering the motions and the entire record, the court will deny plaintiff's motion and grant defendant's motion. In other words, Leah Glass is not having a good day, nor is she having a good night. Denied. Background. Through an adjudicatory process, the Social Security Administration provides benefits to individuals who cannot work because of physical or mental disability. On December 11th, 2009, plaintiff filed an application with the SSA for supplemental security income for an alleged disability that began on October 1st, 2008. Social Security Administration did a review of things. Her claim was initially granted in February of 2010. So 2009, 2010, right? Okay, she was granted. However, following a report of fraud by a private citizen, because we know how that works, somebody gets jealous, somebody gets angry, somebody gets whatever, the SSA CDI unit, the Cooperative Disability Investigations Unit, began an investigation and recommended plaintiff's case be reopened in 2011. 2009, she filed. 2010, she was approved. 2011, they're reviewing her and doing a fraud assessment. Now, the SSA reopened her case and subsequently denied her claim in February of 2012. So, okay, 2009, she filed. 2010, she's approved. 2011, basically, they're doing a CDI review of her. They're sending out investigators to look at things. 2012, they deny her. And again, upon a reconsideration in April 2014. Plaintiff then filed a request for hearing, which was held on August 21st, 2015, in front of the Honorable John Cusker, an administrative law judge. Plaintiff waived her right to appear at the hearing and instead appointed Miss Christine Allison as her non-attorney representative. So essentially, she got a non-attorney. The non-attorney went in on her behalf. Always not a wise choice. At the hearing, Miss Allison appeared and testified in person. Miss Allison's testimony was largely limited to describing her infrequent contact with plaintiff and how plaintiff has been very difficult and has continued to do what she wants to do throughout this process. So in other words, her non-legal rep, her non-attorney representative, threw the claimant under the bus. Ms. Cheryl R. Chandler, an impartial vocational expert, also testified at the hearing. Ms. Chandler and the ALJ confirmed that plaintiff was 43 years old and had at least a high school education, and that she had no substantial gainful activity within the last 15 years. Because remember, back then, they looked at the past 15 years. Now they just look at the past 5 years. The ALJ then gave Ms. Chandler a hypothetical individual and asked her whether there would be any jobs that the individual could perform in the national economy. Okay, simple, straightforward, how they always do it, right? The hypothetical individual had certain functional limitations. We're not going to go through them because they're not hyper relevant here. The bottom line is this. The ALJ had some details that he had to go through related to essentially a CDI investigation. Now, I want you to understand that a CDI investigation is essentially where they will go ahead and, send people out, go on computers, look stuff up about you, etc. Now, I'm going to read to you subnote 9. This is where it talks about the specific investigation that occurred so you understand exactly what's going on. I wish I was hanging out with Rude Rabbit right now because he is stuffing his face with a deep dish. Me loves deep dish. Me loves it. Me loves it way too much. All right, let's get to it. Subnote 9. Despite plaintiff's claims of disabling mental and physical impairments, the ALJ, the judge, noted significant inconsistencies with her statements. In particular, the ALJ pointed out that plaintiff resided in Beverly Hills, Winnetka, not sure how to pronounce it, and Fresno County, California at various points, but only provided the SSA with a post office box in Sacramento as her address, several hundred miles away, that she drove a red Jaguar automobile with expired license tags. Okay, so in other words, what they're saying is, how did this lady afford to live in these super expensive zip codes? Beverly Hills, Winnetka, I have no idea how to pronounce that, and Fresno County. So just to be very clear, she should not have been able to afford that, and she was driving around in a red Jaguar automobile with expired license tags. Now, with that said, people got to live. There's another side to this whole situation. They have to live, they have to survive, they have to be able to exist, right? But at the same time, it's supplemental security income. That means she didn't have enough work history and quarters of coverage in order to go onto the better program, which is SSDI benefits. Let's keep reading. So she's got this red Jaguar automobile, expired license tags that she drives, that the CDI unit investigation indicated that plaintiff referred to herself as Dr. Lee Davis. Again, Dr. Lee Davis, and advertised herself as a legal analyst, a legal commentator, and a law professor. Also, she advertised that she appeared on the Dr. Phil television show as a TV personality and a legal analyst, that she maintained a website for her entertainment business, creative endeavors, and paid her monthly rent with a check from her company, that she published a book in 2012 titled Quotes from the 1960s, Sex, Love, and Rock and Roll. That CDI investigation included interviews with plaintiff's Winnetka landlord, who stated plaintiff never appeared to be physically or mentally disabled and instead was a highly functioning person who shared stories of her business ventures and high career aspirations with the landlord, and that she received earnings as a consultant for University. The ALJ was also troubled by plaintiff denying she had a criminal history as a part of a mental health assessment in 2013, despite previously having been convicted and incarcerated for making a false declaration in court, bank fraud, and bankruptcy fraud. Okay, so what did we learn? We have learned that this particular individual had quite, I mean, they were, Dr. Phil, legal analyst on retention with the university. I mean, this was a highly active person, a highly active attorney. I mean, obviously people felt very connected to the information that they were supposed to, receive from this person. I mean, this is a legal analyst, a pillar, who's also trying to get SSI benefits. So you got to wonder, if you sit back, how does this all come down? All right, so the ALJ is sitting there trying to figure out how limited this claimant actually is. And it doesn't help that the SSA has in the record, an ROI, which is basically the report that the investigators make, explaining all these ridiculous things like Dr. Phil, being a legal analyst for a university, et cetera, et cetera. So at the end of the day, it's kind of a like, who does this person think she is? Now, you add on top of that the next layer, that basically she hires a non-legal representative, a non-attorney, to go into court, and that person doesn't really get to interact with her. And as a result, when the judge asks her, when was the last time you talked to her? The non-legal attorney goes, 4 months ago, 3 months ago, whatever it was. Well, what was the conversation about? Oh, it was about this. It was about that. When you treat your legal representative poorly in the sense of communication, not doing what they advise, etc., you end up with a tough situation where that legal representative has to go in and kind of say, hey, bottom line, I have not been able to deal with this person. This person is, quote unquote, non-compliant. When somebody is non-compliant, right? It makes it tougher for a representative to do their job. So, bottom line is this: she now goes before, essentially, in this case, this is a district court assessment case, right? So, you've got basically initial filing, reconsideration, ALJ hearing, appeals council, and then you have district court. She now goes before the district court seeking to be found disabled. Now, I don't know about you guys, but the reality is this: she had income from a company that she was paying rent. Now, with SSI benefits, you're supposed to earn under SGA, but if you're earning income, there's the $65 rule and the $20 rule, and then every $2 you earn above that, they take away $1. So the bottom line is, she just wouldn't be eligible if she was able to pay rent in those different areas. And they obviously know exactly how much she was paying rent because the first one they're going to go talk to is the landlord. All right, so what can we learn from this situation? Right? We don't want to drag this video out too long. We want this to be direct, to the point, etc. What can we learn? We can learn that number one, when you are an employer and you own your own company and you're also seeking disability benefits, that is a very good sign that you are going to be investigated. If you are receiving disability benefits or you are on SSI or seeking SSI benefits and you are claiming disability benefits through one of those programs, right? SSI, SSDI, and you own your own company, once again, you are prime material to be investigated. Additionally, you have to kind of keep in mind with this situation that when this stuff happens, they're going to go and talk to the people that know you the best. But they are going to collect a ton of information from whatever you put online. And remember, when they get a warrant, they can go into the back end of the websites and collect more metadata. Princess Diana, thank you for the $2 donation. That's absolutely amazing. I didn't see the $5. Let me scroll up real quick. You did. Oh my goodness. Let me check that out real quick. Super thank you to Diana. I super appreciate it. Tomorrow will be 3 years since my princess passed to 16, which is super sad. Princess Diana had a very, very lovely dog, Princess, who passed away. 16 is very good, though. Very good amount of years to get your snuggles in, which is just absolutely amazing. I do have shadow surgery coming up. So, I definitely feel that tension, and it's been growing on me until, basically June 4th, June 5th, June 6th is when it's going to happen. I do super appreciate the $5 and $2 donation. That's super amazing. Super mega thank you, Princess Diana. Diana's been with us for a very long time. I think she has the highest level membership icon. And I think the next membership icon is like a VIP one. It's like a very, very, very very distinct one. So let's go through this real quick. We've now learned that if you are on disability benefits and you have a company that you own, that is a very good prime example where they're likely to go ahead and investigate you. Now, that's more in the modern sense. Back in the day, some friend of hers threw her under the bus. Somebody didn't like her. So apparently she was very good at making corporate relationships, but not very good with, person-to-person relationships. Now, another thing that you should pick up from this is that they were basically following her around in her red Jaguar with the expired tags. And they were letting her go from place A to place B, taking video footage, checking in on her, stuff like that, because they were watching her drive around. Another thing you can pull from this is that they searched through her website. What did she have up? What was she claiming? What was she doing, etc. So I can tell you another thing that's really, really common that I see in the ROIs that is not in this particular case. And that's when you have a message for a company or a service that you provide, so that when they call you as a disabled person seeking information for your disability benefits, and you've got, hey, this is Cindy of Cindy's Cleaning, we'll get right back to you, and we're super excited to work on your house. When you have that stuff, that is a very, very good sign that they are going to investigate your booty. That's the reality. They are going to investigate you, okay? As a result of that, another thing we can pull from this story is, essentially where, just to be very straightforward, she was tied to, existing corporate entities, not just her own company. Because, sometimes you guys will start a company and won't do shit. It won't earn any money, won't make any products, won't give any services. That was not her. Dr. Phil's show. I mean, that's pretty high level right there. And then on top of that, you've got that she finished a book, right? So she's a published person. And then you got Yoon University where she's given, testimony. So one of the things you have to keep in mind is that if you are not staying under the radar, then you're going to end up on the radar. And this is clearly somebody who ended up on the radar. Now, remember, this is back in 2009 that she applied, 2010 that she got approved, and 2011 that she got snookered on, right? Somebody basically snitched on her, said, hey, SSA, go check this woman out. They weren't as set up back then to investigate people. They are significantly more set up nowadays to go and find things about you. So, I guess what I'm getting at with this particular information, this particular thing is, and then there was one other ticket, which was, you notice how they said that she had the ability to drive hundreds of miles to go pick up her mail? She was creating the persona that she lived somewhere else than where she actually lived. So, my point to you with all of this is that if you remember backwards in time, all the way to 2009, 2010, it was a different world. There were things like MySpace. Hold on. Let me look it up real quick. Hold on. What happened in 2010? Okay. All right. So, devastating Haiti earthquake in January, Deepwater Horizon oil spill in the Gulf of Mexico in April, start of the swine flu pandemic. So we're talking back in the day. We're talking like way back. Okay. 15 years ago, there wasn't all this established online stuff. That was like how it is now, where it's, top level, very professional. Back then, people didn't expect to get essentially investigated. They just didn't expect it. It just wasn't part of the gig. And the SSA wasn't really set up that well to do these functions. So another thing you should keep in mind is the distance travel investigation rule. If you live in one place but have your mail go to another place, they examine your capacity to travel. Now, look, she could have had her mail forwarded, stuff like that, from this PO box to that address, whatever. But if they're looking at this and they can see that you have the capacity to travel and you have mental and physical impairments that are supposed to limit that, then you're shooting yourself in the foot, and it's not good. You don't want that. That's a very bad thing. So at the end of the day, you want to go ahead and learn from this case as to what not to do, because let's just call it like it is. You've got the mass driving rule. You have the publication of a business rule. You have the being an employer rule. You have basically, her being on Dr. Phil, advertising as Dr. Lee Davis, advertising as a legal analyst, having a corporate website. And then, of course, sending in an individual into the courtroom that's not really your friend. That's, that is a non-legal person. I mean, think about that. For somebody to pick a non-legal rep, they almost always have to be like a friend that you know. Otherwise, people just hire an attorney because the payment is the same. Like, why would you not just get an attorney? So the reality here is that for her to pick this non-legal rep that then threw her under the bus, that's pretty interesting, because she either went around to attorneys and they rejected her, or it was a situation where she just was so full of the ego that she said, this person will save me, and they couldn't, and basically threw him under the bus. So I think that's very interesting. And now, just a final point about this, when you study and examine the idea of this book, right? So she wrote this book, 2012, titled Quotes from the 1960s, Sex, Love, and Rock and Roll. Okay. The time it would take to get that book going, then to get it published, get it bound, etc. Because remember, this is, the internet isn't as evolved, isn't as set up, right? They still have Kindles. Well, hold on, let's look and see, when did Kindles come out? Let's see what we got here. When did Kindles come out? Hold on. November 2007. So, I mean, these things were barely around then. I mean, they looked horrible too. Look at that thing. Ugh, jeez Louise. I mean, that is sad. That looks like somebody who does not love computers made it. So the point is this, okay? Kindles had been around since 2007. She applied in 2009. She wrote this book in 2012. It was a different world back then. But in order for a person to literally sit there, put together a book like this, obviously the mental impairment argument would be very limited. Obviously the physical impairment, argument would be very limited. I don't see it as reality. Now, with that said, she obviously did not win. Conclusion: for the reasons set forth above, the court will deny plaintiff Lee's Glass motion to stay and grant defendant Andrea M. Saul's motion, that was the commissioner at that time that Trump put in, for judgment and affirmance. A separate order accompanies this memorandum opinion. So the bottom line here is this. She claimed that she was disabled. They claim that she wasn't disabled. There were other arguments used, other vocational assessment studies used. But the thing that really hurt her, the thing that really beat her up, was that they had a lot of information on her from searching the online web. And remember, there's two levels with this. Level one, it's the surface stuff that anybody can access. And level two, it's the warrant stuff that's in the back end of the website that they can pull. So when you're sitting there thinking, well, I've hid my information on Facebook. Well, I've hid my information on, okay, it's not hidden. They can send out a warrant, get access to it, and then go ahead from that, point, perspective, whatever, go and collect more stuff. And one of the things that the average person doesn't realize when it comes to the collection of evidence is that they'll collect one thing. And even if they're allowed to use it, or even if it wasn't perfectly collected, or even if it's not even admissible in court, they'll use that one thing to go ahead and know which direction to look for other stuff. So it's one of those things, you know what I mean? You just got to realize at the end of the day, once they start digging, if they find one little thing, they're going to keep digging. All right. With that said, please remember to like and subscribe. There's hardly any likes right now. Give that like button some love. Give the little ducky a chance to be loved and liked. Come on now. With that said, please remember to subscribe. And also, if you want, I always appreciate it if you go to Disability Resolution Law Firm or Disability Resolution Florida. You just type it into Google, throw some stars up there. I always love reading those in the morning. They always help me kind of get through the day. With that said, and it's very important, I am going to be going live tonight. I'm going to go live for 30 minutes and answer questions for free. And then after that video, we're going to be going specifically over what the commissioner said, the new one, Frank Bisignano, while he was on live television. And I have some opinions about it. I'm very excited to see what he can do. But it also, to me, seems like he's got some sort of verbal disabling conditions that are showing themselves more and more every time he goes and does one of these speeches. So I'm not sure what's going on there, but we'll have that next. So, well, it's actually the video after the next one. I'm going to head in to go ahead and quickly create the thumbnail. Then you know the deal. We put you on the phone. You call in. You get to ask whatever questions you want. As long as they're disability related, we will rock and roll from there. Give me 10 minutes. And then just go to the actual channel, click on the next video, and we should be good to go from there. Attorney Walter Hnot, the most viewed, subscribed to, and clicked on Disability Attorney in America. You have a wonderful, wonderful day, and we'll go from there. Thank you so much. Bye-bye, everybody. Bye-bye. Have a wonderful night, and I'll see you soon. Bye-bye.